Shri K.C. Ramamurty ji. Shri K.C. Ramamurty.
Sir, thank you for permitting me to speak on this very important bill, sir. This bill was long overdue, and I'm happy that it is seeing the light of the day today. So there are a number of positive aspects which we need to appreciate. Among them, sir, the definition and application of the words deposit and deposit takers have been widened to include all those transactions which cannot be brought under the purview of the general laws that have been in force, including the Indian Penal Code, the Reserve Bank of India rules, and in bringing the offenders to purview of law to prosecute and recover the money such people collected from the general public. This is a good move, sir. Secondly, the time bound to complete the process of securing money deposit amounts from the deposit takers have been limited to 180 days. That's also a very good move, because any loss of time, there will be delay in rendering justice. So under section appointing the officer not below the rank of secretary as the competent authority to discharge and supervise the execution and implementation of the intention and purpose of the ordinance is a well thought of step. But if there is any lapse on the part of the competent authority who is appointed in implementing the intention of the ordinance properly, he and those officers who are entrusted with the responsibility should be held responsible for those lapses. So there are a few points which I would like to highlight for the government's knowledge, sir. Sir, clause 24I, as my friend was already discussing, it says that small businesses, proprietorships, partnerships and limited liability partnerships and MSMEs are almost exempted from the purview of this act. So the point to be noted here is that we might be exempting them, thinking that the fraud never happens in those places. I'm sorry, sir, the thinking of fraudsters will begin where our thinking ends. I'm saying this because IMA Group scam in Bangalore, which came to light only recently, has exactly tried to cash on this loophole. The promoters of IMA, instead of collecting money in the form of deposits, made depositors shareholders of his limited liability partnership firm. Now, you cannot prosecute such fraudsters since you are giving exemption to LLPs under section 24I. So I request the Honorable Minister not to be so magnanimous towards such people and companies and amend the clause accordingly, because they take unsecured loans from unrelated parties. There is need to widen the applicability of section 22 of the bill. Secondly, sir, if you look at the rate and number with which such scams are taking place during the last 4 or 5 years, it is mind-boggling. I am giving you the statistics given by none other than our Honorable Law Minister. According to him, CBI has lodged 166 cases in the last 4 years relating to cheat fund and multi-deposit scams. These are only cases registered by the CBI. But if one looks at the RBI data, it indicates that between July 2014 and May 2018, 978 cases of unauthorized schemes were discussed at the state level coordination committee meetings. But what the government has done on these cases is not known. Sir, mere legislation will not do. We don't want paper tigers in the form of legislation. We want action and protection for people from such scamsters. So the announcement, the clause 3 of the bill bans unregulated deposit scheme from 21st February 2019. My concern is that, sir, what about the people who have already invested thousands of crores of rupees, the poor and gullible people who have already invested and lost all their hard-earned money? What is the action that is proposed to be taken on that? So my other point is relating to clause 32 of the ordinance, which deals with application of CRPC. I wish to mention here, sir, that in Karnataka state, we have the Karnataka Protection of Depositors in Financial Establishment Act 2004. Section 18(2) of that act clearly barred application of section 438 of CRPC, which deals with anticipatory bail if the facts and circumstances discloses the commission of the offence punishable under this act. This proved to be effective both from the point of view of the investigator who gets custody of the depositors and from the point of view of the financial institutions also. I would like the Honorable Minister to kindly take note of this act, Karnataka Act. Further, sir, while recovering the assets from erring companies and deposit takers by attaching the same, the onus of proof must be on the person who objects the attachment that the attached property is in no way connected to either the deposit takers or the companies. I am saying this because the burden of proof shifts to the objector. It would be easier to the designated court or competent authority to complete the process of realization of money. Section 12(5) of the Karnataka Act has a provision on this. Sir, there is no provision in the Act for appointment of special public prosecutors in this bill. In our State Act, we have a provision for appointment of the public prosecutors who have put from the advocates who have put in 15 years of or more of service, and which is very effective in the state, sir. Sir, lastly, I would like to mention that RBI gives monetary intelligence to the states, which will not be sufficient for the government or the competent authority to attach properties or take preventive action. And if the act, it might not stand the scrutiny of law. Provision should be made for clear preventive steps. Otherwise, we are concentrating only on post-mortem after the crimes are committed. Government should give a serious thought on how we will be able to prevent such offences. So, last point, sir. The bill becomes effective if it acts as a deterrent for intending fraudsters. How such a dangerous illegal activity which drains thousands of poor families could be prevented is a very important factor which needs to be taken into consideration. With these observations and hoping that Honourable Minister will certainly take note of certain points that I have mentioned, I support the bill and conclude. So, thank you very much.
Thank you, Sri K.C. Ramamurty ji.